Welcome back to your last graveyard shift with me. So I'm sure you've mulled over the riveting subjects of exceptions and Rule 61 over the lunch break. And I just want to find out before I move on to summary judgment whether you have any questions for me on irregular proceedings and or exceptions. Great, so I can accept that you are now fully conversant with these procedures. So I will then make the exam questions a bit more challenging when it All right. The next interlocutory that we need to be dealing with is summary judgment. I guess for those of you who have experience in the Magistrates Court civil stream, or those of you who have experience in the High Court of Namibia, whether it is as a judge's clerk or having litigated, you will at least be acquainted with the term summary judgment. Now, at the outset, I should perhaps say summary judgment is a robust and a very extreme measure which deprives a party of the opportunity to actually defend a claim. So I suppose you can imagine that summary judgment is sparingly granted. This is simply because it is, if granted, deprives a party of its constitutional right to actually present its case in a trial in due course. So even at the outset, the court says, I'm not interested in what you are going to have to say at trial, I'm going to grant judgment. Summary judgment can be granted in limited instances. It can be applied for based on a claim, based on a liquid document, a claim for a liquidated amount of money, delivery of specified movable property, and ejectment. Those are the ejectment is none other than eviction. You remember those tape recorders that we used to have before CDs and DVDs, and you press eject and something comes out. Yeah. Ejectment, it's I think they still have eject or open and close. What is it these days? Anyway, so ejectment is the same as eviction. So, claim based on a liquid document would be a check, negotiable instrument, similar documents. Liquidated amount of money, it means it's an amount of money the value of which is subject to speedy determination, or it is predetermined. So, for instance, you have a contract, and the contract says that I will pay Mr. A 10,000 Namibian dollars. So the claim is for payment, specific performance payment of that $10,000. That would be a liquidated amount of money that's being claimed, payment of 10,000 Namibian dollars. So it's predetermined in the contract. Or I say a liquidated amount is something that it's you will pay me 40,000 Namibian dollars. Let's give you this example. 40,000 Namibian dollars together with interest calculated from 1 January 2017 until 31 December 2017 at the prime interest rate applicable from time to time. Is that a liquidated amount? Well, you say no. Why do you say no? Okay. How do you determine the interest rate from time to time? You phone the bank. Say the party said net banks, the prime rate is the prime rate. You know what that is. So you phone the bank, you say, look, sir, what has the prime rate been this year? From 1 January to 31 December. They're going to say, well, for this period it was 10%, and then for this period it was 12%, and then let's be generous and say it was 13%, and then it was only 8%. This makes up this period. Then you go and you multiply the 40,000 that is owed by the number of days. So you take 10 times 10% for that period, divided by the divided by 365, which is the number of days in a year, times the number of days that this interest rate was applicable. It's a fairly easy sum to do. So isn't it subject to speedy determination? It's certainly liquidated. The court doesn't need an expert to come and tell it how it's going to arrive at that amount. Okay, so that would be where you claim interest. That's one of the examples. It would be liquidated. The next question is, my claim is for contractual damages I suffered because the contract says that you were supposed to grant me vacant occupation of the immovable property at a certain period of time. You didn't, and as a result, I couldn't rent out the property, which is what is my primary business, is renting out properties. So a property of that nature would go for $20,000 a month. You gave it to me 2 months late, so I'm entitled to 2 months damages in the amount of 40,000 Namibian dollars. Is that a liquidated amount? Who says yes? We have one yes. Who says no? Okay, we have a no. 2 no's. The others don't want to say anything. No, it's not a liquidated amount because it's damages, and whether 20,000 Namibian dollars is the going rate for a house of that nature is something that the court can only establish when hearing expert evidence by a property valuator, estate agent of the sort, who then is able to say, yes, I am experienced in the market and I have looked at houses similar to this one in that area and over the past 5 years, and taking everything into consideration, 20,000 is a reasonable rental to calculate for damages. Now let's say the contract says you have to perform, you have to finish the building contract by 1 November 2017. If you don't, then penalties will arise at 500 Namibian dollars per day. So you finish 2 months late, and let's say that's 30 times 500, so it should be about 30,000 that you're claiming as damages arising from your non-performance in the contract. Is that a liquidated amount? Yes, absolutely, because it's been predetermined. All right, so you don't need to call an expert to tell you what that damage is, what those damages are. Good. So, delivery of specified movable property and ejectment. Delivery of specified movable property usually claimed by way of what is called the reivindicatio, which is where an owner of his property is entitled to claim delivery thereof from whomever he finds that property to be in possession of. Okay. Summary judgment, it's important to note the time frame for the application in terms of the previous rules. There was a specific time within which a party, after having received a notice of intention to defend, had to file an application for summary judgment. Presently, though, it's dealt with in the case plan, as we saw earlier, which means that a party will have to indicate in the case plan that he or she intends to apply for summary judgment, and that he or she will do so within a specified period. And then, of course, if that party then doesn't do so within that period and without extension from the court on good cause shown, the court will obviously not allow that party to apply for summary judgment. It's a use it, don't use it, you lose it type of thing. So if you don't use the remedy available for you right at the outset, then you lose it. A defendant cannot apply for summary judgment in respect of a counterclaim. It's one of those considerations you'll have to take into account when deciding whether to bring a counterclaim or to bring an action proper. Summary judgment is an application. It is an application by notice and supporting affidavit, but it is not a supporting or a founding affidavit in the normal sense that you would find with other applications. It has a very specific way in which it is sought. So, for instance, you have to say that the deponent who makes the affidavit has personal knowledge of the claim and the events set out in the particulars of claim, that he can verify the cause of action set out in the particulars of claim by positively swearing to the facts on which the cause of action are based, that in his or her view, the defendant has no bona fide defense to the claim, and that notice of intention to defend was filed with the sole purpose to, or was delivered with the sole purpose to delay the matter. Those four averments must be in the founding affidavit. Now, please bear in mind, and you can actually, LexisNexis brings out a loose leaf binder that deals only with summary judgment, and it's updated with case law as it develops, because summary judgment and the essence of summary judgment is largely dealt with in case law. Because it is such a robust remedy and such an extreme remedy, courts are very particular that parties have to comply specifically, and when I say parties, I mean the plaintiff, needs to comply specifically with the requirements of the founding papers in an affidavit for summary judgment, as well as the procedure for seeking summary judgment. Any defect of whatever nature in that application will lead to the court refusing summary judgment, striking the application, because it is such a robust remedy. The other significant thing about a summary judgment application is that the court will look only at the particulars of claim with its attachments, as well as the affidavit by the respondent. The plaintiff doesn't get the opportunity to file a replying affidavit, so the respondent doesn't get the opportunity to answer, the plaintiff doesn't get the opportunity to respond to what the defendant has said in its affidavit resisting summary judgment. So the only affidavit before the court by the plaintiff is the one dealing with those four issues. Very short affidavit. And then the court looks at the particulars of claim, and the court looks at the opposing affidavit. That's all. The plaintiff doesn't get another say. Now, when a defendant is faced with a summary judgment application, he or she has one of two options. He or she can file an affidavit dealing with their bona fide defense to the claim, or he or she may set up security, both for the claim amount as well as costs. In fact, you will find case law, if I remember correctly, the parties were the late Vincent Sorensen, property developer, he's passed away since, and Desmond Amuniela. There was a case between the two of them, if I recall correctly, some sort, I don't know, I can't recall the exact, although I acted in the matter later, I can't recall what the merits of that was about, but there was a summary judgment application, and Mr. Sorensen, who was the defendant in that matter, had in fact filed an affidavit dealing with a bona fide defense. But then, shortly before judgment, it dawned upon them, after the matter was argued, if I recall correctly, that maybe what is set out in the affidavit isn't really good enough and he's going to face summary judgment. So then he set up security for the claim amount and costs, and in that case, the court couldn't then grant summary judgment. So that course is open to you, to set up security is open to you until just before judgment is granted. Once judgment is granted, it's over and done with. Why would a party set up security for costs, or security for the claim amount and costs? Well, there are a number of reasons, considerations to take into account. The first one would be whether the defendant is in fact able to set up security for the claim amount and the costs. The second one might be that the defendant doesn't want to set out his defense in an affidavit at the outset, simply because that always makes for good cross-examination material for the plaintiff, and maybe doesn't want to play his hand. There can be many reasons. What a defendant shouldn't be allowed to do is to use the method of setting up security for the claim amount and costs in order to delay the inevitable and where he or she absolutely has no defense. But that's not really for the court to decide. If a party of its own accord sets up security for the claim amount and for costs, then that's sufficient to ward off summary judgment. So that's really for the practitioner who's acting for the defendant to make sure that the defendant doesn't abuse the process and flog a dead horse in the sense that he or she has no defense whatsoever. So I suppose the question you have, and which is quite relevant, is what is a bona fide defense? So what is required is not for a party to set up a case which proves beyond a reasonable doubt or beyond any why is it that I don't have my summary judgment? I think I may have lost some of my papers along the way. Anyways, it's not that you have to prove your case or that you have to prove it beyond a reasonable doubt. In any event, is not the onus that you have to meet, but it is, of course, on a balance of probabilities. So you don't need to convince the court that on a balance of probabilities you have a defense and you can ward off this claim. It really is just a bona fide defense, prima facie. So what the court will say is that you give facts, and here you can look also at a judgment in the Supreme Court, De Savino versus Nedbank, incidentally, but not the one in 2017. There's an earlier judgment that deals with summary judgment and what is required of a party in summary judgment proceedings. And the court says, well, at the very least, you have to set up the material facts based upon which you say you have a defense, and then the court will say, if these facts are proven at the trial, would that ward off or be sufficient to create a defense to the claim, if they are proven. You don't need to prove them at this stage. So have a look at that authority, De Savino versus Nedbank. It's an earlier authority. In fact, I'll quickly find you the citation and I'll read to you the relevant portions. So it's De Savino versus Nedbank Namibia Limited. So they've been at it for quite some time. And it's Supreme Court of Appeal case SA 24 of 2010, and it was delivered on 21 June 2012. So from paragraph 23 onwards, the judgment deals with the principles governing summary judgment, and this is really, these principles haven't changed. So one of the ways in which the defendant may successfully avoid summary judgment is by satisfying the court by affidavit that he or she has a bona fide defense to the action. The defendant would normally do this by deposing to facts which, if true, would establish such a defense. So the court doesn't go into the truth of those facts. It just says, well, if you are able to prove the truth of these facts eventually, then it would establish a defense. Under the rules, the affidavit must disclose fully the nature and grounds of the defense and the material facts relied upon therefore. Where the defense is based upon facts and the material facts alleged by the plaintiff are disputed, or where the defendant alleges new facts, the duty of the court is not to attempt to resolve these issues or to determine where the probabilities lie. The inquiry that the court must conduct is foreshadowed in the rules, and it is this. First, has the defendant fully disclosed the nature and grounds of the defense to be raised in the action, and the material facts upon which it is founded? And second, on the facts disclosed in the affidavit, does the defendant appear to have, as to either the whole or the part of the claim, a defense which is bona fide and good in law? If the court is satisfied on these matters, it must refuse summary judgment, either in relation to the whole or part of the claim, as the case may be. While the defendant is not required to deal exhaustively with the facts and the evidence relied upon to substantiate them, the defendant must at least disclose the defense to be raised and the material facts upon which it is based with sufficient particularity and completeness to enable the court to decide whether the affidavit discloses a bona fide defense. Where the statements of fact are ambiguous or fail to canvass matters essential to the defense raised, then the affidavit does not comply with the rule. All right. So, De Savino versus Nedbank, the earlier one, deals with the principles relating to summary judgment, and there you are able to see what is required of a party who wants to file an affidavit resisting summary judgment. And that there it's set up how a bona fide defense is set out. Now, of course, a defense need not always be on the material facts, or based on material facts, and a defense on the merits. Let's say, for instance, the particulars of claim are excipiable in that it discloses no cause of action. Let's refer for a moment back to the Mr. A paying Mr. B example I gave you earlier. And now Mr. A says, no, sorry. You rely on all the grounds that you would set out for your exception. So there's no cause of action. It's excipiable. Do you think that's sufficient to ward off the summary judgment application? The answer is yes. The court should not grant summary judgment on the particulars of claim that discloses no cause of action. But now remember, that's your opinion. What if the court was to find that it's not excipiable? Then you have no defense on the merits. So when it's a clear cut, it's excipiable, what I usually do is to deal with the preliminary issues. So to say there's a defect in the application for summary judgment, plus it's excipiable, plus you're dealing with damages here, plus, and now I'll deal with the merits. So because you have only the one chance to ward off by way of summary judgment. Now, say for instance, the court says, yes, I'm not going to grant summary judgment because your particulars of claim are excipiable, and so you are granted the opportunity to amend. Now, the plaintiff goes and he or she amends the particulars of claim. Okay. Can they then again apply for summary judgment? No. Done and dusted. You can't go again. If you, however, withdraw your action and institute a new action, you would be entitled to apply for summary judgment again. Also, let's say, for instance, one of your prayers, prayer 1, is confirming. Those are your prayers. Confirming the cancellation, so it's one of those instances where a party has paid $100,000 as a deposit for a sale of property, and then the other party didn't want to do what they had to do, so this party called his breach and cancelled the agreement. Alternatively, herewith cancels the agreement. That's how you plead. So you confirm the cancellation of the agreement, repayment of the deposit of 100,000 Namibian dollars, interest on this at the rate of 20% per annum, cost of suit, further alternative relief. Can summary judgment be granted on all of these? All right, so no, because remember, you can only seek restitution if the agreement is cancelled. And what you're saying to the court is, I'm not really sure that I've properly cancelled this agreement, so please confirm the cancellation of the agreement also. And the court is going to say, well, I can't grant you order confirming the cancellation of an agreement by summary judgment, and if I can't grant you that, then I can't grant you these either. Okay, the court will never grant you an order saying further or alternative relief. That really is just added in there so that I can somehow say to the court, well, based on what is set out in paragraph 5, can you actually, in addition to payment, change the interest now to change something else, or I want whatever. So it really is just a practice that the court will never grant an order saying further or alternative relief. Okay, cost of suit. So all of this is fine. You can grant summary judgment on this, but you cannot because you haven't granted summary judgment. So you won't, yeah, exactly, because you can't. You can't grant summary judgment on these if you haven't confirmed that. Another example, only one more, then we'll move on. You have an agreement, a written agreement, which contains a non-variation clause, but the agreement says you must pay 10,000 Namibian dollars, whereas in fact it was 100,000 Namibian dollars. Okay, so your claims would be 1, and then 3, 4, and 5 the same as we previously had. Can you grant summary judgment on that? You seek rectification from the court. That's actual relief that you seek. But the court can't grant summary judgment on this. And if it can't grant summary judgment on this, it also can't on these. You follow? So that's just to explain some of the different examples of how these things present themselves and how certain praise in a particulars of claim may influence the granting or not of summary judgment, and may be open to a defendant to raise these issues in defense to an application for summary judgment. How is security set? Set by way of a bond of security, and the amount is determined by the taxing master, so with the full claim, and the amount of costs would be determined by the taxing master. And then what happens is it's either paid into court, or it can be paid into a trust account, and a legal practitioner can issue an unequivocal or an unconditional guarantee that amount is available for security throughout the duration of the trial. All right, so that concludes summary judgments. The rule reads, the court may, at the hearing of an application for summary judgment, make an order as to costs as the court considers just. But if the plaintiff makes an application under this rule, where the case is not within the terms of Subrule 1, meaning Subrule 1 being on a liquid document, liquidated amount of money, delivery or ejectment, or the plaintiff, in the opinion of the court, knew or ought to have reasonably known that the defendant relies on a contention which would entitle him or her leave to defend, the court may order that the action be stayed until the plaintiff has paid the defendant's cost, and may further order that such costs be taxed on a scale as between legal practitioner and client. So attorney and client costs. Remember, we don't speak about attorneys here because we are legal practitioners in terms of the Act, so legal practitioner and client, same as attorney and client. What the court is actually saying, or the rules are actually saying, is plaintiff, I will penalize you if you abuse this process. And you can abuse the process in one of two ways. You can seek summary judgment in matters where it's not competent, you knew or ought reasonably to have known that the defendant relies on a contention that entitles it being the defendant, to defend. And if you, in either of these circumstances, nevertheless proceed to pursue an application for summary judgment, then I may actually grant a special cost order against you, Mr. Plaintiff, to pay the defendant's costs, and I will stay the proceedings. I'm allowed to say, Mr. Plaintiff, you will not proceed with this action until you have paid the defendant's costs. That is in order to avoid parties abusing the summary judgment procedure. Now, I can explain to you why that has probably happened, is that parties sometimes seek summary judgment just to get the defendant's version on affidavit right at the outset and then use it later at the trial for cross-examination, etc., etc. Often these affidavits resisting summary judgment are drawn up in an early stage in the proceedings and under time pressure, etc., etc., and then mistakes in that affidavit come back to bite the defendant much later. So, of course, practitioners must take care when drafting such opposing affidavits. So that has been the practice well, a practice like that has developed. It's not everyone who operates like that, but it does happen. So the court says, well, you should only apply for summary judgment where you are entitled to it. And you're certainly not entitled to summary judgment when you seek summary judgment for relief not competent for summary judgment, or you knew or ought reasonably to have known that the defendant relies on a contention which would entitle him or her or it to defend the action. Number one is easy. Number two happens where, for instance, there's an exchange of there's a letter of demand by the plaintiff to the defendant, and then the defendant's lawyer writes back and says, you know what, I'm not going to pay you because you are in fact in breach of this agreement because you didn't do this, that, and the other. So my client doesn't need to pay you because my client couldn't do what he had to do under the agreement because of what you did, and therefore you are in fact indebted to my client. Now you receive this letter of demand, so you know what the plaintiff or the defendant is saying in answer to your claim. You that nevertheless proceed to summary judgment. So what I do in case plans where I act for a defendant and this has happened, I say to the plaintiff in the case plan, reserve the defendant's right to invoke Rule 60 sub-Rule 11 and seek a special cost order and seek a stay of the action if summary judgment is applied for and pursued, simply because the plaintiff should have known in the circumstances that if the defendant is able to prove this at a trial, then that would constitute a defense to the claim. What's also open to a plaintiff is once an affidavit resisting summary judgment is received, to then say, I'm not pursuing this, give the defendant leave to defend and let the action proceed. Even then, in those circumstances, if one of these two present themselves, the court is still able to make such a cost order. Even though the application there's been wasted costs. Usually the parties would agree costs in the cause. Once an affidavit is filed and the plaintiff now for the first time sees what the defendant is going to say, then the parties would agree cost in the cause and they withdraw the summary judgment application and the defendant is granted leave to defend. If, however, the summary judgment is abandoned and the application and the defendant granted leave to defend by agreement and one of these situations present themselves, then the court may very well still grant an order in respect of the wasted costs up to that point. Postponements. When, how, and by whom can it be applied for? A postponement must be applied for as soon as practically possible after a party becomes aware of the necessity to apply for a postponement. It's applied for by complying with the requirements of Rule 32(9) and 10, and then launching a formal and substantive application for postponement. And it can be applied for by either of the parties to the suit, depending on the circumstances of the matter. Now, sometimes a postponement may be required because of something the other party did or didn't do. And in such a case, the court would be more readily grant the application for a postponement and would obviously penalize the other party with a cost order. So although it's the other party seeking the postponement, the circumstances and basis for the postponement was brought about by the actions of another party, and therefore that party is then faced with a cost order. So the principles relating to the granting or refusing of an application for postponement are fairly straightforward. There's a lot of case law dealing with postponement. I'm not going to refer to case law now. You can read that in your own time. It really depends on the circumstances of the matter. But essentially, what the court's approach is that matters should proceed on the dates that they were set down for, and postponements are not there for the taking. So the court will consider the circumstances of the matter, whether there were previous postponements, the remissness of the party seeking the postponement, prejudice to the other party, costs, etc., and would then make a decision for a postponement. It has happened that parties have arrived at court and sought a postponement of the matter, and it's been refused. It's not strange. It has happened. It does happen. The court takes the overall conduct of the parties and the practitioners in the matter into consideration. And if a party has been remiss to the extent that it's inexcusable, a court will not grant a postponement of the matter. So it's a substantive application. Sometimes where it's fairly long before the set down dates and the parties agree amongst themselves that the matter won't be ready for trial, or that one of the counsel is no longer available, or whatever, they can arrange to see the judge in chambers to say, we've reached this agreement. Would you still want a substantive application, or can we agree now to set new dates for this trial? And how the longer it is before the set down, the more likely it is that the judge would say, no, you don't need to bring a formal application. Well, I mean, by the third time this happens, the judge is going to say, no, look, now you are just messing around, so now bring your application. But normally the judge will take a pragmatic approach and say, well, I think in the circumstances, let's now already agree on new dates. So diligence from the practitioner's side, early enough, a week before the time, court will probably say bring an application. So it's always advisable to either call a status hearing or to arrange a meeting with the judge in chambers to explain the situation, to say the parties agree that this matter is not ready to proceed, and therefore would you require the parties to bring a formal application, and if so, give directions on how that should be done, because ultimately it is the court's decision whether a postponement should be granted. It is not for the parties to decide that. They can agree that it should be applied for, but they don't have the power to grant a postponement. And as I said, it would very much depend on the circumstances of the matters. So you have to consider the requirement and the circumstances relating to the postponement in question versus the overriding objective of the new ethos of civil litigation in Namibia, which we've dealt with yesterday, which says, well, a party needs to, or matters need to be adjudicated speedily and in a cost-effective manner for the proper administration of justice, etc., etc. So is this postponement in conflict with the overriding principle? And if yes, then probably it shouldn't be granted unless it would result in a gross injustice to one of the parties. And then you can have a look at case law relating to postponements. There are a number. You can actually just type in High Court of Namibia postponement principles, and you'll find a number on SAFLI. And you can read through them. We wouldn't have time to deal with postponements now. So then condonation. Condonation, similarly, is not something the parties can agree on. It's something that the court must order. So irrespective of whether a party or whether your opponent intends to defend or oppose your application for your application for condonation, you still need to apply to court for the condonation to be granted. It's again a substantive interlocutory application that can only be brought after compliance with Rule 32.9 and 32.10. In order to succeed with condonation, you need to show good cause. Good cause has two elements. Firstly, the deponent needs to explain fully the delay or default and how it was brought about, and must have a bona fide defense on the merits, or good prospects of success. So I want to refer you to the matter of QNet Capital. That's a High Court case. Just want to open that. And you will see at paragraph 13 onwards, the judge deals with. One of the important cases on condonation is that of Beekes and another versus Southwest Africa Building Society and 5 others, where Langa AJA stipulated the principles applicable to applications for condonation, even under the new rules. In dealing with condonation, the learned judge of appeal stated the following. An application for condonation is not a mere formality. The trigger for it is non-compliance with the rules of court. Accordingly, once there has been non-compliance, the applicant should, without delay, apply for condonation and comply with the rules. In seeking condonation, the applicants have to make out their cases on the papers submitted to explain the delay and the failure to comply with the rules. The explanation must be full, detailed, and accurate in order to enable the court to understand clearly the reasons for it. At paragraph 20, the court reasoned as follows regarding prospects of success. I have borne in mind that prospects of success are often an element, sometimes an important factor that could influence a decision whether or not to grant condonation in a proper case. It is, however, also true that in the jurisprudence of both South Africa and Namibia, although prospects of success would normally be a factor in considering whether or not condonation should be granted, this is not always the case when non-compliance of the rules is flagrant and there is glaring and inexplicable disregard for the processes of court. It therefore appears that for an application for condonation to succeed, it is important for the applicant to address the twin elements of a reasonable explanation for the delay or non-compliance, together with the issue of prospects of success. If there should be any doubt about this, the Supreme Court spoke unequivocally on this issue in Petrus versus Roman Catholic that one. O'Regan AJA spoke in the following terms. In determining whether to grant condonation, a court will consider whether the explanation is sufficient to warrant the grant of condonation and will also consider the litigant's prospects of success on the merits, save in cases of flagrant non-compliance with the rules, which demonstrate a glaring and inexplicable disregard for the processes of court. So, what the court is saying, if there's any doubt, you can be sure our Supreme Court has said you need to show good cause by explaining the default or delay or the non-compliance with the rules, as well as showing that you have a bona fide defense on the merits. the worse the non-compliance, the greater your defense on the merits or good prospects of success should be. If your non-compliance is flagrant and shows a total disregard, an inexplicable disregard for the rules and the processes of court, then it doesn't matter how good your defense is, the court will not grant you condemnation. So it really should be seen as two hurdles. The first one being the non-compliance. If you've explained it, but it is so inexplicable and flagrant a disregard of the rules of process, then you can't even lift your leg over the hurdle. You're stuck here. You're not getting further. If you've explained it and it's flagrant, but at least there's some explanation, probably gross negligence on the side of the practitioner or party. So you're getting your leg over, but the hind leg is stuck on this hurdle, because now you have to show a very good bona fide defense on the merits to get the other leg over the hurdle. If you have shown that the default or delay was entirely innocent, it was simply an issue where, for instance, the court order was granted but it contained an inaccuracy, or it was sent to a different firm and not yours and didn't come to your knowledge or whatever, then you're over the hurdle, actually, and it doesn't matter so much what the bona fide defense is, because you can't be blamed for the default. You see how this works. So think of the hurdle, you're stuck before the hurdle, or you get your one foot over and the other one is still stuck, and then you get him over, or you just fly over. Okay. Condemnation remains an indulgence that the court is granting, and it is a discretion. It's in the court's discretion whether to grant condemnation, and if it does so, to what extent. And usually, granting condemnation will also result in a cost order, even though this against the successful party in the condemnation application, which means because you are seeking an indulgence and because you were at fault, the other party should be entitled to wasted costs occasioned by your non-compliance. The situation would be different, for instance, where your opponent opposes the application for condemnation and does so obstructively or vexatiously. Then, in that circumstance, a litigant would be entitled to ask the court, and the court should probably consider granting such a punitive cost order in the circumstances, because it should deter parties from opposing applications of this nature of condemnation, where clearly on the papers a good case has been made out for condemnation to be granted, and another party is simply being opportunistic or chasing costs or being obstructive or whatever the case may be for opposing the application for condemnation. It's an application that is brought on a daily basis for a number of things. So any possible non-compliance that you can think of, or so any possible rule that you can think of, there can be non-compliance of, and if there can be non-compliance, it's competent of being the subject of an application for condemnation. So essentially, it matters less. So if you don't at all deal with a bona fide defense, you've got trouble. You need to deal with both. But the court will pay less attention to that, because the court is not at condemnation stage establishing where the probabilities lie and really dealing with the merits of the matter. It's prima facie. So it would be easy for you to establish a case of good cause. If you don't deal with that at all, and that's what happened in the QNet Capital case, which I refer, that party didn't deal with prospects of success at all, or bona fide defense. It didn't deal with it. And the court said, well, you need to. And you especially need to where your explanation for the default or delay shows flagrant disregard. So it will just weigh less, in the sense that the court will be less minded with whether or not you have a bona fide defense or good prospects of success, where the delay was innocent. But you need to at least show something. If from that the court sees that, well, you in any event have no defense whatsoever on the merits, why should I grant you condemnation? Why should you be allowed to proceed with this matter? You see. So it's not that it doesn't matter, it just matters less. Does that make sense? It's the weight. So it's when the one weighs more, the other one weighs less. So it weighs more in your, look, I mean, this is just the scales. It weighs more in your favor that the non-compliance was innocent, and therefore this need not be that heavy. It goes up, the weighing of these two. Yes, you need to stipulate, and what you would be required to do is to seek an order in respect of each and every one of them. So condemnation for this, condemnation for this, condemnation for this, and condemnation for this. And they would be listed as separate prayers in your notice of motion. They can be dealt with in the same application, yes. You don't need to bring a separate application for each one of them. So that brings us to amendment of pleadings. And amendments of pleadings is what I'm going to be spending the rest of the afternoon on. So I think now we should take a comfort break. It's 4 minutes past 3. So let's be back here at 3:15, and then I will deal with amendments and have some time for final questions and answers, speak to you about the exam, and then I'll be out of your hair.